Good morning, everybody, and welcome to this meeting of the Licensing Board on the 29th of May 2025. A little bit of housekeeping before we carry on. If the fire alarm is activated, it will not be a test. There is not a test for today. Please take the stairs and do not use the lift. And please, will you congregate in the Holly Square, which is the assembly point. Please do not use the lifts, and officers will assist and advise you as you leave. Thank you. Moving on to the film, I would like to advise that if any filming it takes place, anyone in attendance in the public areas may have their image captured. I urge anyone filming the proceedings to avoid filming members of the public, particularly if there are children present. Does anyone intend to film the meeting? Thank you. Let's get that. Would everyone present please ensure that their mobile phones are turned to silent and they are not used to make or receive phone calls while this meeting is in progress? Are there any members who would wish to speak under Council Procedure 20.1? No. Thank you. And have we any apologies for absence? Okay. Are there any declarations of interest amongst members? No. Agenda item 3, the application for Josh Bay, Josh Gap, Broadstairs, Kent, has now been deferred to a later date because the applicant and the representatives were unable to attend today. Thank you. Moving on to agenda item 4, the application for a new premises licence at Fusion Basement, 17B, Cliff Terrace, Margate. We are here to consider an application for a new licence at Fusion Basement, 17 Cliff Terrace, Margate, in accordance with the Licensing Act of 2003. We will hear the parties in following order. The technical support manager to present the report, questions from the responsible authorities for the technical support manager, and representatives responsible for the responsible authorities to present their case. The licensing officer will present their case and conditions, questions for the licensing officer from the applicant, interested parties in their present case to present their case, questions for the interested parties, at the applicant to present their case, and questions for the applicant. Once all the relevant representations have been made, with exception of board members of the Democratic Services Officer and the legal officer, you will be asked to leave the chamber so that the licensing board can deliberate and come to a decision on your application. This should take around 30 minutes, after which you will be invited back to the chamber to announce the decision. Okay, would the technical support manager, Alison Brock, please present the report?
Good morning, everyone. An application was received for a new premises licence at Fusion 17B Cliff Terrace, Margate. The application was advertised as per under the Licensing Act, and we've received a number of representations. We received 35 representations from the public. These are attached. A representation from Kent Fire and Rescue. Conditions have been agreed with the Environmental Health team. There are some attached to this report, but I have today passed around some new ones that were literally agreed yesterday. And a number of conditions have also been agreed with the police and the TDC Senior Licensing Officer. These are attached. So it's for the board to listen to everything and make their decision. Thank you.
Do members have any questions for the technical support manager? Okay. We move on to part A. On behalf of the applicant, would the applicant now present their application? Mr. Jeremy Denning, the applicant's representative, will be speaking on behalf of Wayne Johnson.
If you could just press the button on your mic.
17B Cliff Terrace first became into use as a nightclub in 1938. The building is still within the same family ownership of the Corellius family. It has many incarnations over the years, the last being Fusion nightclub, which closed in 2015. Having made the application for a licence, we have taken on board the concerns raised by objectors to the grant of a licence. We have agreed with the licensing department at the council to reduce the opening hours from those sought in the original application of 6 a.m. to 1 a.m. on Monday, Tuesday and Thursday, and 3 p.m. on Friday and Saturday. 3 a.m. on Friday and Saturday. The premises are to be closed on Wednesday and Sunday. We've extended the time to which we have asked for the premises to be open to 3 p.m. on Friday and Saturday to allow for the closure of Bar Nothing at 2:30 a.m. on Fridays and Saturdays, so that everyone are not leaving both premises at the same time. We have spent over £90,000 refurbishing the premises, including making the premises as soundproof as practicable. We have agreed to condition in the licence proposed by Environmental Health that should prevent any impact from noise on the operation of Bar Nothing. We will have 4 SIA registered door staff to work at the premises from 9 o'clock until close each evening. Each evening the premises are open, and this will ensure that the premises are properly supervised. Children will not be permitted on the premises on any day after 8 o'clock in the evening. We've entered into a priority arrangement with Central Cars so that patrons leaving the premises do not have to wait long for their taxi to arrive. They just have to press a button on the bar and they get a ticket, and then within 5 minutes the taxis arrive. We wish to respect the needs of our neighbours as residents not to be affected by the granting of the licence, and the basement premises is well suited to the use of a club, as there are no windows and now outdoor seating area for the club. We have commissioned an acoustics report which has been accepted by the council, and we have followed all its recommendations to ensure that therefore noise is kept to a minimum as required by Environmental Health. Okay.
This is purely if you've got a question. When you do your bit, obviously, then
No, okay. Are there any questions from Environmental Health? Are there any questions from the licensing officer? No. Do any of the interested parties have any questions for the applicant? If you could please state your name before you speak. Mr. Yates?
Thank you. Rob Yates, resident and councillor, although I'm speaking as a resident on this committee. There's just 2 questions. So you've said you've done everything to make the premises as soundproofed as practicable. Can you list some of those measures? For example, I've been to this committee at Faith and Strangers, and they talked about, I'm not an acoustic expert, but they talked about like rubber mountings between the speakers and the wall. They talked about like acoustic dampening put on the ceilings and on the walls. So that's my first question. The second question is, you mentioned respecting the needs of the residents. Have you met all the residents who are directly adjacent to your premises and spoken to them about the plans, and how have those conversations gone?
On all the first ones with the speakers and stuff like that, everything gone in, it's all acoustics been put in, added acoustics been gone in there as well, and rubbers on the chains of the speakers. All the speakers are pointing inward, and you're welcome to come and look at it, check it any time. Any speakers on the floor and now on foam padding. It took a bit of time to adjust to it, which we did say to residents, bear with us, we are adjusting and getting things right, and now it's all right. it all went through the acoustics test, and the acoustic people come round, they've done samples and everything, and it all meets the criteria of it on the acoustic side.
I'm not the residents.
Sorry?
Have you spoken to the resident?
Have I spoken to the resident? There's one lady that come down, and I've spoken to her, it's recorded in our book, because we write down everything, and she said she couldn't hear no noise, no music, but the vibration, and that's when we got the acoustic under the speakers, and that stopped the vibration. Now that's done, it's solved. The same again, you can come and look at it and check it, it's all there in place.
Okay. Are there any more questions? You are, Mr.
I'm Patrick McDougall.
Sorry,
Oh, sorry. Pardon me, Patrick McDougall from 14 Terrace. Just
I guess a couple of questions also. Oh, there we go. So you've not talked to me, or you've talked to anybody in 14, which is a Grade 2 listed building,
Right.
at all. There's been absolutely no contact. So I was just interested in your taking account of the local residents. And
We thought 14 was empty because it didn't look like numbers there, because it's above the shop where the shutter's down.
no, number 14 is the Grade 2 listed.
Is that round the corner?
It's on the corner.
So that's like about 4 properties away.
So it's 14 and 15. There are 5 flats.
Yeah.
Yeah, I'm on the ground floor.
When we say we've taken on board, sorry, when we say we've taken on board representations, we've gone through all the representations that have been made to the committee, and we've gone through those and tried to address everything we could possibly do to address those concerns.
Okay,
So I'm not saying we've had a meeting, but we have seen them. There've been 35 representations made, plus a petition, and we've gone through that in detail and tried to do things. We've lessened the hours. We're going to quite a stringent level of between us and the bar above, which has been agreed with license.
Okay, I'll come on to that with my second question, if that's okay, but thank you. But I don't think you have taken account. I mean, obviously, we had to proactively raise issues, which you've now read, but you've had no contact with us. Your Facebook page would suggest otherwise. Soundproofing is practical. That's an extraordinary phrase, isn't it?
What, sorry?
Soundproofing is practicable. So if the soundproofing, you're doing what's practicable, but if that still doesn't meet the requirements...
No, we're doing the soundproofing. We under the proposed conditions being put forward by Environmental Health,
Yes.
unless we do and can demonstrate that there is a difference in noise between the premises... It's been tested between the residential premises, and there's no problem at all.
Well, it hasn't been tested in 14... I'm sorry. Oh, just questions, yes? Okay.
Just getting back to that, sorry.
Yes, of course.
So the one that's been tested is directly above it. Now, if this is directly above it and there's no noise there and you're 3 away, if there's no noise directly above, I can't, but we can get a sound test on your one. That's not a problem at all.
Is it true that your basement is against my party wall?
Not as far as I know it ain't.
Interesting. Worth looking at that.
We can get a sound test in to make sure that it complies.
But the bit... I have a question for Environmental Health then, because they talk about ceilings, but not walls. Is that later? Okay.
Yeah. There's solid concrete walls in the basement. There's solid concrete walls.
Oh, that's...
They're quite thick, because this used to be an air raid shelter in the war, so they are solid. But being like you're 14, so we've got 15, we're 16, 17. There's, between us and you, there's another building. So but we can do a sound test, that's not a problem, and we can make sure that's fine. Yeah.
I would expect one to have been done before the licence is granted. Thank you.
Get one
Yes.
we liaison with you.
Oh, sorry. Yeah.
Thank you very much. At this point, we are simply asking questions, and you will have an opportunity to make your comments later down the list of activities to be done as part of the hearing. So if you could just restrict yourself to just asking questions.
Okay, thank you. Are there any more? Yes. Are there any more questions? Could you give your name, please?
Hello, Julian Moore. I'd like to ask Mr. Johnson if he thinks that speakers in 1938, when it was first a nightclub, are the same as they are today.
Is it what, sorry?
If the speakers in nightclubs are the same in 1938, when it was first a nightclub, as you said in your statement, do you think the speakers and the noise emitted from nightclubs are the same today in 2025 as they were in 1938?
They were probably louder then because you didn't have laws and regulations keeping the volume down, so they could then they can have it as loud as they want. Now it's restricted and monitored.
Shows a basic lack of knowledge.
So therefore, now it's lower because like environment and health, they go, well, you can't have it that loud, so it's monitored. And as for like, are they louder? No, they're probably louder, but it's monitored and it's restricted.
No further questions.
Sorry, just to add, please can we keep the questions to be relevant to the actual licensing application and to the licensing objectives, which are to prevent crime and disorder, public safety and public nuisance, and for protection from children from harm. The question should not be related to personal properties. Thank you.
Can I have your name, please?
Hello, my name's Eldine Johnson. I'm actually a resident in number 17, and it's my business, bar nothing. My question is, you've said you've done sound testing in the flat above, which is my flat. The volume that the music was being played in Fusion, when you did that testing, yes, I couldn't hear it in my flat. However, when you're actually operating, I have video recordings and decibel testings of hearing it in my apartment, affecting myself and my children. So yes, you can say that you did those tests, but where are the documentation of what the level you're playing when you're open, as opposed to when you're actually doing the testing?
We've got that there. I'm not saying it's not true. I'm not something like that. But it was tested on a specification at 100 decibels or 90 decibels. And they took the limiters off the system to test it at them decibels. Now the limiters are set at 88 or 77, I think we're going down. So as for it being that's impossible because the system cuts out. And not only that, but the same again, we've got video evidence and sound recordings that your music over the top of ours, we can hear it, and your windows are rattling like that. But that's not in the thing, so sorry about that. Yeah, but we're just putting an argument there.
Wayne, with all due respect, you're the agent of change. I've been operating for 6 years without any complaint. The noise, the question that I'm asking is, your acoustic engineer that came in, or the sound testing that was done, he said that it was being played at 95 decibels. Yep. I could hear it in the bar. Our bar music wasn't on. I could hear it. But my question to you is, he said it would be played at 90.
No, that's what they sound tested at. It's not played at 90. They sound test it to get a decibel reading. So they put it up to maximum volume, which is 90 decibels, what they do the sound test. So they get all the readings correct at that testing. But these restricted environmental health, you don't play it at 90. And downstairs, we sound test it, we decibel test it 4 or 5 times through the night, and we're only hitting about 72, 74. And we can hear your one over. Come down.
Do you have those records?
Yeah, and as for no 6 years with no complaints, a lot of these complaints on here about bar nothing, if you read through them.
Excuse me.
Yeah, read the complaints.
Can you please switch off your mic as well? Thank you. You can only speak at the invitation of the chair. As soon as you've asked your question, please switch off your mic. Thank you.
Are there any more questions? You are Mr.
Mr. Felix Cohen.
Mr. Felix Cohen.
I'm a resident of Paragon Court, the building opposite, and representing a number of residents there as well. My question is, Wayne, Mr. Johnson, you said you have a log of interactions with all the residents. We spoke on the Thursday of your temporary event notice. Sorry? I'm speaking as a resident opposite. Do you have a record of that conversation?
Yeah, that record is logged in on the complaints book. We put that down as a complaint. Even though it's speaking, we still mark it down as a complaint. So it's on the book.
May I ask a follow-up?
Yeah.
So you said...
that was when you walked past, remember you said it's...
Sorry, Chair, if I can...
Sorry, it's not. We're not having conversations. We are just having questions and answers.
In your answer to the first question, you said you'd only had one complaint from a resident, so you're not counting my complaint in your logged incidents. In your response to the first question from interested parties, you said you only had one complaint from a local resident. are you not counting my complaint and the complaints of residents in my building?
The other resident, she said, I'm not complaining. She said, but it's just a vibration. I can't hear the noise, the music whatsoever. It's just a vibration. And that was on...
Sorry, can you switch on your microphone?
We got some sound acoustic foam in, and we done it on a Monday. So that got rid of that, and I spoke to the lady again, and she said, no, that's stopped, but yours is the one complaint that's in the book. And I don't think it was really a complaint as well, but we did write in, and it was about the door being open, and you said, oh, is that door going to be shut? And we said it shuts at 10, and when we shut the door, you couldn't hear it whatsoever, and you didn't follow back, so we thought it was all okay, which I assume it is okay, because you didn't follow back. Yeah.
You can ask your questions further down the line. Thank you.
I'm representing 4 people here, formally. So can I ask a question on behalf of one of the other people, please?
Yeah, that's fine.
Thank you. You were mentioning one complaint.
Sorry, where does the other person that you represent, whereabouts are they in the building or in the road?
So Jojo lives at number 16, which is next door to you, and also Katie and Emma live above me in the building, and they've asked me to represent them today. I won't use all 4 slots, don't worry. Of course, context, yes. I wanted to find out, because I know that Jojo has submitted formal noise complaints to Thanet Council. I wondered in your one complaint that you've had whether those were included as well, or whether you're not aware of those complaints. Okay, thank you. That is lodged with yourselves. Okay, those are with the council. I have the evidence here. Thank you.
Are there any more questions? Then we can move on to the next item.
There's a request that if we can swap, instead of campfire, let's have environmental health.
Okay. Yeah. Okay. Do we have any of the committee members having any questions for the applicant?
No.
Thank you. I don't know whether this is a relevant question, but clearly there is a good deal of opposition from the local residents. What grounds do you have for believing that there is a requirement or a desire for an establishment to be open so late with music? Thank you.
We've already operated the premises on 10s for 10 days, and we've had a sufficient number coming into that. It's only a small club. We're not, you've got to put it into perspective. At the moment, we're limited to 60 because of fire regulations. We don't want any more in the club than maximum, including staff, 150. This is, and you've been getting in. Been getting in.
We've had 60 in, and we've had a queue, which a queue's like 1 in, 1 out, but very quiet. Which there's no complaints from the residents about that. So it is working, 1 in, 1 out. And when people leave, they literally instantly, they're gone. So outside there's no rubbish, there's no people loitering, there's no shouting, because there's been nothing to do with that. And a lot of our customers as well, they're good customers, they're from Bar Nothing, so they come out of there and then come down to us. So it's a good little community sort of thing there. Yeah. Yeah. You're laughing. Most of them are. They're the ones that don't come down.
The next item, please could the Environmental Health Officer present their case?
Thank you. Good morning, Chair and members. I'm Amanda Berry. I'm a Senior Environmental Health Officer for TDC and representing environmental health as the responsible authority for the prevention of public nuisance under the Licensing Act. It is our role to assess whether appropriate conditions can be attached to the licence to uphold the licensing objectives, specifically in relation to noise and disturbance. We have raised concerns regarding the application directly with the applicant, specifically in relation to the risk of noise, nuisance to neighbouring residential properties and businesses. Following a site visit, discussions and amendments to the application and the submission of a noise impact assessment, Environmental Health have been able to agree conditions which are both reasonable and enforceable and which mitigate unacceptable noise. Therefore, environmental health no longer offer a formal representation, but if it assists the subcommittee, I am happy to go into some detail about the background of the conditions. Okay, thank you. In terms of the premises description, it's at a basement level of a 3-storey property. The building is brick built, mid-terrace, with a entrance on Cliff Terrace. The internal layout includes a bar, a dance floor and a separate DJ area. The venue has no windows. The ceiling construction that separates Fusion from Bar Nothing directly above is unknown and unclear whether there are any flanking transmissions, but complaints following 2 temporary events notices indicate a very basic level of sound reduction. There is a residential flat on the 1st and 2nd floor. Bar Nothing is in between. The proposed premises is in close proximity to residential properties at the rear of Cliff Terrace and Ethelbert Road. Many of these are elevated bedrooms at 3 and 4 storeys, so overlook the rear yard of the premises. The original application sought extensive hours that were well outside any neighbouring operations. At the site visit, it was agreed that there would be a substantial reduction in the proposed operating hours and that the requirement for an upfront noise impact assessment. This was submitted and reviewed yesterday. It has been undertaken by a competent and experienced acoustic consultant using the correct methodology, and recommendations on noise mitigation and control to meet limits have been proposed. The applicant has been advised by planning enforcement that they will have to apply for a certificate of lawful use or seek planning permission for a nightclub. That's the comments from planning enforcement. Although Environmental Health made representations, the first 10 subsequently proceeded due to a procedural error, and a complaint was received from a rear neighbour and the premises above regarding loud music affecting the operation of their business. I understand that there have been a number of representations made on noise as a consequence from users of the business above. The agent of change principle puts the responsibility for mitigating noise impacts on the applicant as the party introducing change to an existing environment. A new licensed premises would be responsible for ensuring they don't cause an unacceptable nuisance. The noise impact assessment, which has measured background noise at the most sensitive time of night and has established a music level not to be exceeded at source to meet that limit. The noise impact assessment has also made a number of recommendations. There are lots of recommendations in the report, which I understand the applicant intends to comply with. There's a lot of them, but some of them are including obviously the reduced operation hours we'd already agreed, but the requirement for a lobby door, no use of the rear yard for patrons, a sound limiter set to 90 decibels in order to achieve the limit that's established as a condition, no live music, sound reduction requirements for the separating ceiling and floor with bar nothing above. Yes, and an airborne noise limit at neighbouring dwellings. So there are a number of others as well, but I won't go into all of those. You've all got a copy of the conditions that were agreed yesterday. I can go through those if you wanted me to. Those conditions will need to go on if members agree and grant consent. Those conditions will need to go on in Annex 3 as conditions imposed by hearing, as a number of them apply to deregulated entertainment, so it's important they go on in Annex 3. So there's conditions around sound insulation, noise limits, a requirement to not exceed certain levels from the set by a sound limiter. The rear yard should not be used by patrons. They will need to submit a noise management plan to be agreed. There's a number of extensive conditions that have been agreed by the applicant. So I think that's how we've been able to withdraw our representations, which seeks to provide a balance or strike a balance between the potential benefits of a licensed premises with the existing licensed premises directly above and the rights of residents to enjoy their homes without unreasonable disturbance.
Thank you. Has the applicant any questions for the environmental officer? Does the licensing team have any questions for the... Do any of the interested parties have any questions for the environmental health? You are Mr.
Julian Moore. So is it my understanding that he will have to take his whole ceiling down inside his nightclub, soundproof it, and then put a new ceiling back up so the noise doesn't go up, as I did in my restaurant when I had, obviously, you know, because you did my application. So I just wondered if that's what has to happen, because obviously that's not happened yet, as the sound leaks through the floor and into the residents' properties above, which is why I wasn't allowed a late license for music, because of that exact reason. But it seems like Mr. Wayne Johnson, for some reason well, you know, it seems if he does all these things, he's allowed to have that. So is that the case, that he has to take the whole ceiling down, replace and soundproof everything with insulation, etc., then put a new ceiling up? Is that how that regulation is enforced? And will you look at that? And that's my basic question. How is that enforced? Because obviously you can't just shove cotton wool inside it, can he? So I imagine that's going to be a lot of more money you're going to have to spend to be able to do that. And I just wondered if that's the case, please, EHO. Thank you.
Thank you. Thank you for your question. I don't know if you've got a copy of the conditions in front of you, but if you want to look at condition 10 specifically, that relates to the standard of sound insulation required, and condition 11 requires post-completion testing. So that will be done within 1 month of granting of consent, if members do grant consent. And so that will test the degree of sound insulation. Bar nothing will need to give access to allow this. And that will test to see whether we can achieve the 50, or the applicants can achieve the 53. They may well achieve it now. They may need to add additional sound insulation. They have a noise specialist who's engaged by them, who's a competent acoustic consultant, so can carry out the tests and make recommendations to comply with that condition.
That's, yeah, that seems so. It does seem by here, obviously, because there's an old construction, there's floorboards and sound creaks through everywhere. And I've been in Bar Nothing, and I've been in the toilets, the back door, the kitchen, every area of it, and all you can hear is Mr. Johnson's dum, dum, dum music coming up through the floorboards, sound, bass, etc. So with the acoustics and the airborne bits and bobs and decibels, will all that be taken in account? And will you check it as well so that it's compliant, if he's allowed to obviously have his license today?
There are a number of conditions. So there's an airborne sound limit, which applies to the 1 metre in front of the facade of a residential receptor. There's a structure-borne condition around sound insulation. There's a requirement for post-completion testing. There's also a condition on the sound limit that the music can be played at, and that has to be secured by a sound limiter. All of these will have to be, a post-completion report will have to be provided, and at any point we are enforcing authority, so we can go in and check that.
One more point. Did you check that the back, in the back corridor, there's an air conditioning unit where the sound leaks out through? And I wonder if that's been checked, or if that can be dampened as well, because that leaks up to the properties above. And I've got videos of that if you would like to see them.
I've reviewed the noise impact assessment, and it's been carried out in accordance with the correct methodology. It was assessed at 2-3 in the morning at the quietest time. Those measurements were taken with the music in operation at Fusion, so that would have been taken into account.
Thank you. Mr. Yates?
Thank you, Chair. Yeah, just a few questions. The first one is, you mentioned planning permission. I wasn't quite clear what you meant by that. Does the venue currently have the correct planning permission? And I've got two other questions, so I'll just carry on. That's the first one. The second one is, so is it fair to say that the noise levels at the venue currently are not proven to be sufficient to meet these terms? Because I think it's not clear from the conversation so far whether that is the case or not. I don't really understand what condition 12 is. Condition 8 is suspended for temporarily 1 month period and is amended to what? Can someone explain that to me? And hopefully you can. Thanks.
Thank you. The planning, I'm just reporting on what's been said to the applicant from planning enforcement, which is they will need to submit a certificate of lawful use to demonstrate that it has operated as a nightclub to benefit from planning consent in the sui generis nightclub class. So that will be on the applicant to provide that to planning. Then the second question was around whether you're meeting current standards. And that's where actually that ties into condition 12. So in order to, some of the conditions are already compliant, but the condition that relates to the sound installation has not been tested yet. That will be tested in the next month. So condition 12 is a temporary condition to reduce the current noise output, reduce the sound limit to take into account that month while the assessment is done of the sound insulation. To take account of that. But all the other conditions are compliant.
Thank you.
Sorry, just to add, the planning question is not a relevant question that is relating to the actual licensing objectives. So if we can keep all questions that are strictly relating to the licensing objectives. Thank you.
Hello, Laura Barnes. Just a clarifying question about that point on number 12 on the agreed conditions. Does that mean that Mr. Wayne Johnson is able to, if the licence is approved today on these new agreed conditions, will Fusion be allowed to remain open for the month while the work is being carried out? Thank you.
At a reduced noise level, yes, it's given a month's grace period, operating at 80 decibels. If you look at the condition, it also reduces a lot of the low frequency noise. That may not sound like a small reduction, but 80 decibels, 10 decibels is a halving of sound energy, so that is significant reduction.
Thank you.
Thank you, Patrick Medjugorje. Yeah, thank you, Environmental Health. Just, I guess, a couple of technical questions so I can understand a little bit more would be great. You talked about post-completion testing. I think you might just have answered that. So if a license is granted today, it's granted on the basis that there will be no retrospective breach rather than it still being a temporary license until it's been proven that the sound levels are at the right level. Is that correct?
Yes, that was correct.
Thank you. And the noise levels, is it noise from music only? I appreciate you can't be responsible for your punters, but you are the whole licence is coming in. Question on that?
Yes, the condition relates to music noise level. That can be conditioned and controlled, and noise from patrons has to be dealt with differently. It doesn't fall under those conditions, and that's where the noise management plan is of use and controlling by condition. So we've put a condition that patrons shouldn't use the rear of the property because particularly at the back there's a lot of residential bedrooms overlooking the site. We have concerns about patrons being out the rear, but that's been agreed. They'll go out the front. That's limited as well to maximum of 10. Their drinks aren't allowed to be taken outside at the same time. So there are other conditions to try and control that, and a supporting noise management plan will be required so we can address some of those points as well.
Okay, thank you. Just certainly, John, who I'm representing as well, reiterated the point about certainly the noise levels in bar, nothing coming up from below, so that's noted and correct. I wondered, we have grade 2 status on our building on the corner, and therefore it's only single glazing. We can't do anything apart from single glazing on floors 1 and above. So actually the noise levels out in the street would be significant there. I appreciate you're talking about the music, and that's also communicated through the concrete structures of all the buildings that drum and bass carries extraordinarily through. So I think certainly having readings done in 14 should be and 15 should be a prerequisite for the granting of the licence. I would hope that's the case, and the council would look at that.
Just on that point, there's a condition 3 will remain on the licence, and that has a condition that relates to music, and the LAAQ 15 minutes shall be controlled to be 5 decibels below the background noise level, which is an L90. I appreciate it's quite a technical set of parameters, but what that effectively means is inaudibility at 1 metre from the facade of any neighbouring premises in terms of airborne noise, and then the controls inside with the sound limiter and the sound insulation to protect structure-borne noise.
Thank you. Final question on that then. Obviously, if there is a retrospective noise issue and complaints are received, is there any open data associated with how long it actually takes for the issue to be solved or the licence revoked for the council? How does one actually go about it?
It would be in breach of the conditions, so that would be an enforcement issue.
And is there an example of how long that enforcement might take?
I can't answer that, but I don't know if a colleague can.
Sorry, I think, gentlemen, are you withdrawing your question? You did? No, okay, fine, thank you.
Again, Felix Cohen, speaking for the residents of Paragon Court opposite the premises, and also to echo Patrick's point there. We're all in grade 2 listed buildings. We all have single glazed windows. We're all subjected to a lot of noise, as Mr. Johnson says. If the door is open, the club music is entirely audible in my bedroom. There's no licensing condition regarding whether his door is open or closed. Obviously, in order to have his 60, 70, 150 patrons, he will need to have that door open throughout the evening. My question for environmental health is, there doesn't seem to be any conditions regarding noise from the front of the premises. Will you make amendments for that?
There are a number of recommendations in the noise impact assessment that are also required. I appreciate you don't have those in front of you, but there is a requirement for a lobby door to fit door closures to ensure that noise is mitigated.
Is a question for the committee maybe, but is there a reason we've not had the noise impact assessment shared?
Yeah, that would be for the officers to recommend.
I mean, it only came in yesterday, but it's I haven't an issue. I don't know if the applicant has, of Ross putting it up on the website. No.
I mean, I do appreciate it only came in yesterday, and turnaround on things is difficult. It's frustrating that we're at the hearing where this will be approved or not approved, and you're offering to put it up on the website now. If it can't be shared today, we can't comment.
Forgive me, but it's for environmental health to agree these conditions. The document was requested by us, we've reviewed it, we're satisfied with those, and so we have agreed the noise impact assessment, but I'm happy for that to be available for members of the public to have a look.
Can I go to Karen Clark from Kent Fire and Rescue?
Just a question about the door. Where would the lobby door be fitted, please?
I haven't seen the detail of that, but assuming it would be down in the basement area.
There's a door on the bottom of the stairs and there's a door at the top of the stairs. Both were self-closers.
The door at the top is being changed as well. It's going to be for one of the fire things. We're putting that as pulling the door back and taking it facing that door. So, and that's going to be classed as a fire door. So it's on closure the same as one at the bottom. So there's both on self-closures, one at the bottom, one at the top, and that one's at the top. We'll be liaising with yourself about. Remember we said about a second door. So that's in progress.
Sorry, can I just to your requirement for a lobby door is just to have one. To have a lobby door. So are you considering the door at the bottom to be a suitable lobby door?
I haven't signed that element off, but yes, as long as it's closed, it's not an issue where it is for us in terms of noise.
Okay, I think that's that. I think we have one more. Just one more.
I'll keep it to one more. It seems slightly, I mean, I don't know how the planning and the environmental issues work here, but it seems very unprecedented to open a nightclub underneath something else which is kind of operating as a nightclub. It sounds to me like a brother and a sister in their bedrooms turning the volume up to kind of drown each other out. Is this a standard precedent? Because
we just deal with each case on its merits when we receive an application. It's not unheard of, but there's nothing to stop an application being received from two businesses on top of each other.
Yeah, I fully understand. You need to assess them all independently. It's just 2 + 2 maybe equals 5. Thank you.
Okay, on that note, I would ask any members if they have any questions. Councillor Bayford.
Thank you. I'd just like to ask, if should the licence be granted, with the ongoing conditions such as numbers 5, 6 and 7, rather than the ones that... sorry? Right, okay. So rather than the ones that have to be agreed initially, is there any plan to monitor this, or do you just wait to hear complaints before somebody tries to enforce? Thank you.
We respond to complaints. So if a complaint comes in, it would go to licensing enforcement and environmental health, and then we provide relevant noise control services, and that could include noise recorders, visits, planned visits, call out, and any evidence of a breach of condition would be passed to legal for a view to prosecution.
So it's not monitored?
Yes. Yes, it is monitored. No, it's not proactively. We will take a complaint first.
Good morning. I'm Karen Clark, Senior Building Safety Inspector from Kent Fire and Rescue. It's my colleague Rachel Allerton, also Building Fire Safety Inspector. Our involvement comes from being a statutory consultee on a licence application. We consider the licence in the grant of public safety. In this case, it was noted that it was a basement initially, which is a much greater risk for fire safety. We consider means of escape. It was noted on this that we were concerned about the means of escape, with the plan that we had wasn't very clear. So that was our main concern. We didn't have an awful lot of details when the application came through. We didn't have capacity figures, which we were very concerned about. It relates to the number of escape routes that you've got. So capacity figures are a huge concern for us. Figures that were provided, I think early stages were 250, which we thought was unlikely to be feasible in this kind of premises. We were concerned with the plans that we had through that the escape routes appeared to narrow, which isn't acceptable because you can have a crush situation, and we wanted further documentation on fire risk assessments, etc., before we went ahead. So that was our basis of our representation. Since then, we found out that the TENS application had gone through. We were very concerned about numbers, so we made a visit last week. There were 3 escape routes at the time, which we assessed. There's an escape route at the rear, we call that the bar escape route. Yeah, so as you go down the stairs, I don't know how familiar everybody is with the building, but you've got an open staircase at the front, you go down into the basement, and then we've got a cloakroom, and we go into the main bar area. To the far sort of side of that and out to the rear was a route that was marked as an escape route. We quite quickly established that we didn't feel that that was a safe escape route for several reasons. One, that it narrowed, it didn't meet the standard width. We need 750 millimetres for an escape route to be valid. It's got a very low ceiling, it's got hazards on it, and when you get outside there are other issues, but mainly from the width of that we've discounted that as an escape route. We've looked at the rear escape route, which is wide enough, it's got the openings that we require, and then we have the main escape route going out. So these were our main concerns looking at the building. When we're considering fire in a place, particularly a basement, a standard that we'd be looking at, standard in terms of occupancy, would be 60. Huge concerns with firefighting in a basement. We've got to commit firefighters to go down. Everything rises in a fire, so it's a very difficult place to deal with a fire. For that reason, we had our crews come out as well to assess access. They would only be able to access the premises from the front. Again, adds an extra concern from firefighting point of view. We have assessed these escape routes now. The rear escape route from the dance floor goes up the back, so we said that is an acceptable escape route. We've got some concerns that there is a boiler at the top of that, but I think we can get around that. But that is a clear escape route, suitable openings. It goes outside slightly narrows when we get out there, but I think we could get along there. It's not a huge distance to a place of ultimate safety. So that escape route we could accept. The other escape route goes straight out to the front. However, in fire safety, we have to consider that one of those escape routes has become compromised. If there was a fire, that the sort of standard is that you consider one is unusable. For that reason, we would consider there is only one viable escape route. The width being 750, we would consider this a higher risk premises for the reasons I've outlined. It's a basement, it's a nightclub, it's licensed, there's alcohol involved. So we'd be looking at an occupancy with those conditions, it would be maximum of 80 people in the premises at any time to evacuate safely. The issue we've got at the moment is also an inward opening door. With an inward opening door on the front escape, you've got it will be a maximum of 60 people because you've got to get past that door. And we were talking about the premises later on, the door being closed. You can't have a lot of people getting to a door. That's the reasons for that. On site, we also found other concerns which were to do with fire spread, the construction of the building. So fire detection was also a problem. That's been addressed. We haven't got certification for that, but from what we saw at the time, I don't know whether any has been extended yet. We can come back to that, but not all the premises was covered with fire detection. As a minimum, we'd want it in escape routes. Some of the routes weren't covered with detection, and when initially they had smoke detection, heat detection rather than smoke detection in the main areas, which doesn't give a quick enough warning. So that was changed while we were there, very proactive with that. They got that changed. However, additional detection would be needed, so a fire can't develop unnoticed. We'd need the early warning. We'd also need people upstairs to know of a fire. That, I believe, is going to be quite quickly addressed. The other issues are the structure of the building and the compartmentation. We were told that that was going to be addressed, but we haven't had any further information on that. At the moment, there are lots of areas where fire could spread through the building, through the nightclub, through the basement itself, and possibly into the areas above. So they're the big things that we look at in terms of fire safety. I'd also like to point out that some of the details on the application aren't as we saw things. In particular, just noted that it says an evacuation policy is in place that was to the satisfaction of the fire authority. We hadn't been consulted. We wouldn't take that consultation before a licence is submitted. So that's been misrepresented in that. There are a few other issues with that application that not quite how it is, but we're still waiting a lot further information at the moment. Anything else, Rachel, that you need to add?
Just a little bit of emergency lighting.
Oh, okay. Yeah. Do you want to cover that?
Yeah. Hello, Rachel Allerton. There was a little bit of a lack of some emergency lighting, which I think is going to be addressed. Yeah. Oh, brilliant. Okay.
Excuse me? We shouldn't speak over someone's presentations.
And obviously, the inward opening front door was a concern with us, but I think you're addressing that. We just need a copy of the fire risk assessment, and we're waiting for a couple of other documents, aren't we? But
yeah. So, following from that visit, we issued an emergency prohibition notice, which was in our powers to do. We were considering how we would work that, but an emergency prohibition to limit the number of people to 60 at any time, including staff. It is vital that that is adhered to. It's not safe for more people unless we can have, you know, a lot more information and mitigation as to why that would be the case. But at the moment, we wouldn't change on that. It's a great concern that premises can open and we're not be consulted with the TENS, but we know that's a slight issue. But we were gravely concerned to find that it was open with no limit on, or a very loose limit on numbers initially.
Thank you. Would the applicant like to ask any questions to the fire and rescue?
A lot of stuff what you've said we've already been addressing now. To a better team in there. A lot of the in between with the gaps and all that, that's all been done. The lighting's been done, and there's more smoke alarms coming. We've had CAS come in and put them in. We're concentrating on that staircase now. Not that we're making up, like you said, because the other two, but it's going around that, and the door as well has already been in hand with the door. So a lot of these procedures of what we said to you about getting them done, they've come through quicker and their teams jump straight on them.
Not really.
Can I just say we're quite happy to adhere to whatever limits you provide. So we won't. If you say 60, then it'll be
Yeah, we're
60.
fine with that.
And if you come back and when we've put all the reports in, you say it's 80, whatever it is, we will adhere to.
Can I just interrupt there? We are only asking questions, not making statements.
Oh,
sorry.
Okay.
Okay.
No,
Sorry.
more questions. Sorry.
Okay, does the licensing team have any questions for the applicant?
I'd like to ask.
Well, I come to members' questions after. The licensing team doesn't have any questions, as I understand. That's okay. Do any of the interested parties have any questions? Okay, Mr. Yates.
Yeah, just like 3 questions. Firstly, I think the one thing that concerned me greatly, because I'm a councillor as well, is that you've just said that the Kent Fire and Rescue Service do not get consulted during TENS, granting temporary event notice licences, and that sounds incredibly insane that we just allowed a. So what are the Kent Fire and Rescue Service doing to make sure that you're going to be consulted in the future with TENS? Because we've just allowed a club to be opened with 200 people when you think there should only be 60. So what are you doing to improve that process? That's my first question. Thanks.
Alison Brock.
Temporary events notices under the Licensing Act, the only consultees for those are environmental health and the licensing and the police. They're the only people that have to be consulted.
Do we have any more questions from... can I ask the gentleman in the black jacket?
Yeah, Julian Moore. So operating under a temporary events notice without the proper fire restrictions in place, what kind of care do you have as a business owner, that's my question, to your customers and the safety of your customers coming in, that you wouldn't research this to put it in place first before opening?
Yeah, just another point. Is it normal for an applicant to claim that their evacuation process has been agreed with the Kent Fire and Rescue Service?
I can't make a statement on that. That's not a question I could answer.
Well, I think, let me rephrase the question. So you've said that the applicant has misrepresented the views of the Kent Fire and Rescue Service by saying their evacuation process is in line with the Kent Fire and Rescue Service. But you're saying...
It wasn't phrased quite that way.
Okay.
I can't say whether it's normal. I'm just making a statement on this application.
Thanks.
Are there any more questions? Then could I ask members if they have any questions?
Yes, I'd like to speak to the fire.
Pat Moore?
Could you tell me if there was a fire and the back doors open, people went out in the back, how much space do they have to be clear of the building?
You have to have a continuous way out, which that back exit does. You go upstairs, out of the exit of the back, and then turn left, and there's an alleyway. And it's about, 50 metres perhaps, but by that point you are clear of the building, and then you've got 50 metres down a rear alleyway before you get to the road, and then could spread even further. So that is a route we would consider acceptable from the dance floor, and obviously from the front, if you were using that escape, you're out into the road. So the external routes are fine.
Just one more question for the
No
fire.
more questions from the object. No more questions from the object.
We have moved on. Okay. Okay, in that case, can we move on to the... Can we please then ask Kent Police to present their... She's
she's agreed conditions with them. She's not here.
Okay, then if everybody's happy, we can move on.
Point of order, how do we ask questions to the police if they're not here?
There's nothing we can do if the police are not here, unfortunately. I'm not going to take any more questions because the police aren't here. That is the item agenda we're discussing at the moment, and I will move on to the licensing officer's report. Thank you. We can't give an answer to someone can't answer a question if the officers that are not here. That will be something for us to discuss after the meeting. Yeah, could I refer to the legal officer then?
From a public safety point of view, if the police had not agreed any type of objectives with the applicant, then they will be present and they will be for the questions to be asked. It's the same with the fire risk. If the fire risk did not agree any objectives, then they wouldn't have been here because they have concerns, hence why they are here and hence why there are questions for them. So there is no requirement for the police to be here and for questions to be asked for objectives that has already been agreed. Thank you.
On that note, can we move on to, please, can the licensing officer present the report?
Good morning, Chair. Thank you. A site visit was carried out by myself and colleagues on the 30th of April this year. Some proposed conditions were discussed and a lengthy email sent to the applicant. The conditions were agreed. There's some 17 conditions. I'm quite happy to go through these if anybody wants me to. However, I believe that copies of my conditions have been given to anybody that wanted them.
Okay, thank you. Are there any questions for the licensing officer from the applicant? Okay, thank you very much. And then I've learned. Do any of the interested parties have any questions for licensing? Gentlemen, you are Mr. Sorry,
Mr. Cohen.
Mr. Cohen.
Sorry, it was just. I'm sorry, and this may be a waste of time for everybody, but if we can have a précis of those 17 amendments, because I'm not sure, as interested parties, we have seen them. Okay. In that case, we have had them shared. Sorry, it's unclear. And just, Chair, I'm sorry to do this. The agreed terms with the police, I know we've moved past that. Were they also part of the agenda, or are there new agreed terms that have not been shared?
That I would have to check.
The conditions that are there, the ones that the licensing officer just talked about, are the ones that her and the police agreed with the applicant. They all were there at the same time. They'd been agreed with the police and the licensing team.
Thanks for the clarification.
Yeah, just on that point, you said the terms have been agreed with the police and the licensing team. Can the licensing officer then speak about whether there have been incidents related to this new venue from the police? Have there been any calls out because of the TENS licence being granted for this venue?
Yeah, hi there. I can't clarify that, I'm afraid.
In that case, we can move on to. Do any members of the licensing committee have any questions? No, thank you. Okay, so we move on to Part B, the case on behalf of the interested parties who have made a representation. The first person will be Kat Staffel.
Kat's not going to be speaking today, thank you.
Okay. Then we can move on to Mr. Julian. Is it Julian Moore?
Me straight away.
Yes.
No question then.
Sorry, just before you start, I just want to remind all parties again that the questions have to be very relevant to the actual application. Thank you.
Of course.
Sorry, if Julian needs a break, I could maybe do with a 2-minute break if there'd be a chance to use the restroom at some point today. No breaks?
I would like to follow
Okay,
the
no
agenda.
problem. So as a local resident, I find it intimidating to see so many people and strangers on the street of a new existing bar that's opened up as I walk past back from my restaurant towards my house every night. I find the level of noise that comes from the nightlife in Thanet, which I've lived here for 7 years on that corner, to be acceptable. To have more people come along is just going to be more chaos. It's going to be more a detrimental effect on the neighbourhood, on the sleep we barely get at the moment. I believe that the taxis, when he says he's going to get taxis for clearing people up at the aftermath of when people leave the club, getting taxis is not going to happen because it's very impossible to get a taxi in Thanet late at night. So the fact that he thinks it's going to happen quite quickly in the aftermath to be gone is not really fair. Mr. Johnson's not local. He didn't really know the area existed until he asked the landlord of the nightclub for a flat and then ended up with the nightclub. So he has no really care for the area. And that kind of worries me that if he's given this license today, that he'll just continue to do what he feels like, because he seems like a bit of a wolf in sheep's clothing, where he operates under his own rules and does what he wants until he's told by the council or by us, or hopefully with the HO and everyone else, to actually operate as he should be operating. And to come into a neighbourhood where it's quite calm and everyone is, as Mr. Johnson said, it's a nice neighbourhood, but it's about to be turned into a different neighbourhood if you grant this application today. Again, if you're going to a nightclub, you don't go to dance. And he's got gambling machines in his establishment. So if you're under the influence, you're then encouraged by him to then gamble and waste more money. And I don't understand why a nightclub would have that in it. If it doesn't really seem a convivial atmosphere to then, to be drunk and then fleeced of your money potentially. It doesn't really seem as good faith. It seems like it's primarily there for profit rather than the people to have a good time when they are there. And then the detrimental effect on the business above. On the opening night, we asked Mr. Johnson to come into the bar, and he didn't give a toss. He said it's a commercial business, it doesn't matter, even though there were residents around. He wouldn't turn the music down, had no care for it whatsoever, and accused me of bullying him. I mean, come on.
Sorry, can you stick to...
Yep, sticking to the points. So, yeah, so along the points of the objectives, noise pollution, overcrowding, security, the potential for crime. On the opening night, whilst walking to Bar Nothing, I saw people doing cocaine in the street and then going back into Mr. Johnson's bar. I talked to him about that, and he said I was a liar. I don't think I am. I have better things to do with my time.
Sorry, I think you're...
That's the potential for crime. So crime's happening outside the street.
Sorry. Can you switch away? That you are making accusations, not asking for information.
I did go to the police and report it the day after, so there has been a report from the police under temporary events notice, just for a reply for Mr. Glace's question. Thank you. I think that's about all I've got to say. I'm sure everyone else will say it better. Thank you.
Would the applicant like to respond?
You say that Mr. Johnson is not a local man. He has a restaurant at Westwood. His wife has a restaurant.
We both have a restaurant at
Both of
Westwood.
them.
Yeah.
Well,
It's a big restaurant.
Sorry,
We have about 160 people in it, so we do have...
Sorry.
I will take some legal advice, though.
Just going to add, we are going to move on to the next person, but just to add from the applicant, Mr. Julian Moore, in your statement, do you have any statement to make regarding the actual objectives?
I believe I just covered.
Okay. Thank you. Chair, can we move on to Mrs. Ellie Topham, please?
Yes. Please can Ellie Topham please
She's
present
not
her
here
case?
today,
She's
sorry.
not here today either. Okay, then can we move on to Patrick McDougall? Thank you.
Thank you. So just to restate, I'm in flat 14, and I'm here representing myself and two other flatmates above me, 14 Cliff Terrace, and also Jojo at 16. I'm not sure if this is a kind of a rhetorical thing or not. Obviously, I think you stated there are 35 direct objections, and then there was a petition signed by, I believe, 256 local residents. Have those all been considered by everybody in the room already, or do I need to sort of read through my specific complaints for those challenges?
I'll just clarify that.
Thank you.
If you would state what the objections are on behalf of, but just as one.
Okay, thank you. I mean, obviously, as you say, and the form for filling out is based on the prevention of public nuisance, and protection of children from harm, public safety. I don't know, sort of, all of them kind of say the same sort of things, which is about the additional number of people who will be on the streets. Certainly, I've witnessed issues with people on the streets just with the Bar Nothing crowd, who tend to be a very liberal, friendly crowd over the years. So certainly doubling the number of people, I guess, coming in there is going to cause issues. I do think the 5 minutes for a taxi that was stated probably isn't accurate. I've really struggled.
Sorry, that's not a question. That's
Oh, sorry. Who am I questioning?
You are.
I thought I was stating my objections.
Yeah. Okay. Fair enough. Sorry.
Thank you. So public safety, certainly, fighting in the street, I've witnessed. I think maybe if I just sort of summarise the points then overall. So I think my overall concern is there's no consultation with me or anybody in the block from the applicant. Nothing. Obviously, it's been suggested that will happen retrospectively. We do have a petition of 250 local residents objecting. I can't comment on that because I didn't sign it because I wanted to submit my own as well, but that's a very significant undertaking. Our buildings are grade 2 listed. They have single glazing above, so any noise coming out from that flat, and indeed I appreciate that the licence isn't responsible for people on the streets, but that's the case. All the flats and the houses there are interconnected. I believe, and I've been told informally, that my basement does go up against the extended ground floor. If it doesn't, it's all solid concrete, so that sound is going to transmit, and no testing has been done there. So I would like clarification from the planning to see whether that actually is against my wall, because the environmental enforcement notices are about ceilings. There's nothing about walls in terms of actually asking, although I do appreciate that the sound levels are important. So that party wall is important. Any noise in my flat before 11 o'clock, I understand, wouldn't be covered by this licensing, and that would be handled elsewhere, but I was expecting a neighbour to move in, not a nightclub. There are examples of Bar Nothing having to close early because of the noise coming through. I understand that's being addressed maybe with a new ceiling. Guests staying in the flats have been disturbed also, and I've got written testimony to that. Again, beyond the call, but I think the whole approach of local businesses working together, understand free shots have been offered to get people to go into the club. You might have to strike that out, apologies. There have been reported scuffles and verbal and physical issues on the street literally in the last 2 weeks, 3 weeks since it's been open, so that has been reported. Multiple noise complaints have been filed from number 16, with children and mental health cited as major issues there. I went through a 2-year planning process associated with my own flat, with it being grade 2 listed. If I have thumping bass coming through walls
Sorry,
now.
I think you're bordering on statement rather than a questioning to the...
Oh, okay. So final question. This is my section when I think I can do this. From my own flat's point of view,
Sorry,
and environmental...
could you just...
I've only got one more.
Sorry, just to add to the point, I believe what the chair is saying is that your statement has to be relevant to the actual objectives.
Well, the objectives is public nuisance and the impact on my life, I believe, and the lives of all the people that live around that area. So,
if you can't see that, it's crazy.
So on a purely personal level, obviously, if I do have noise coming through my flat, then, does that become worthless, unsellable? Can I actually live in it? But I think, for Fusion to remain open, one other point, the environmental health have granted the license till 2:30 or I think 3 o'clock closing. I presume that's a direct result of Bar Nothing having a license until 2 o'clock to avoid multiple sets of people out on the street. As Bar Nothing is the incumbent, surely it should be till 1 o'clock for the new licensee rather than beyond, because that will impact on all the residents for an extra hour and extra 2 hours of drinking. So that seems very surprising. And I would have thought, a temporary license maybe until 1 o'clock on Friday and Saturday. I don't know if there's a precedent to this, but for another 3 months to prove all of this is actually going to happen rather than granting it, then retrospectively having to try and pick up on the fire issues that have been raised, the noise issues that have been raised, would seem an obvious way of going if you want to test the water. Because I'm deeply concerned about what will happen if this is granted on a permanent basis right now. Thank you.
Thank you. Would the applicant like to respond? Ask a question to the gentleman.
We're happy to come and put the sound engineer. We'll get the sound engineer to come and to testing and under the conditions.
Yeah, sorry, you're not asking a question. Sorry, you're making a statement. Ask a question. Yes.
You could ask me if I would like you to do that.
Would you like us to do that?
Well, it's long overdue, and that would be for everybody on our Taran block and number 16 and the people at the other side as well. I don't believe there's been enough diligence done at all. Thank you.
Okay, on that note, can we move on? The next person on my list is Natalie Ribb.
She's not here today,
She's
sadly.
not here either. Okay. Then can we? Then can we move on to Laura Barnes to present her case?
Hi, my name's Laura Barnes. I'm a resident. My only point that I would like to make today in a statement is just around compliance with the objectives that have been agreed with the EHO and with police and licensing. I'm an employee of Bar Nothing and a local resident, and so I've been on site and I've been around when a lot of these conversations have been taking place from the experience of being upstairs. And my concern is around when the club is open and complaints are submitted, if they're going to receive the license and given a 1 month temporary period and complaints and they're only sort of instance of being monitored as to whether Fusion are being compliant with the conditions of their license, if it's granted today, is going to be made via complaints. That means that if they're not compliant, that as residents and as employees, because we're also physically affected by the volume and the vibrations coming up through the floor in the bar, that we're still going to have to be experiencing the potential of a really disruptive public nuisance environment, and the only measure of that being complaints being made without any actual monitoring taking place. So that's my only statement for today. Thank you.
Sorry, does the applicant doesn't have any questions to that? Firstly, I'm going to give an apology because I didn't ask the officers if they had any further questions. Do members have any questions? Okay, fine. Then can I move on to Adeline Johnson?
Hello, hi everybody. My name's Aldine, Aldine Johnson. I am a resident and the business owner, number 17 Cliff Terrace. So I'm in the building where Fusion is in the basement. As a resident, as a mother of 2 young children, and as a business owner, I'm deeply concerned about my future, to be honest, and my mental health with what's been going on. The noise that is coming through from the basement, I understand that there's been a statement that there has been testing and agreements made. However, the actual experience is overwhelming. The noise that is coming into my business and into my apartment is unreasonable. I've had to close my business on the first weekend that they were open, on both the Friday and the Sunday evening, because it was impossible to stay open with the noise coming through from the basement. My customers have complained. My DJs have packed up and left. My tarot reader that I have on a Thursday evening has had to cancel any commitments they've had for reading for any of my customers, because this can only be done at a volume where he doesn't have to compete with the sound coming through. My business is 80% background noise, like background music. So we're a lounge bar where we use a stereo with background music. I only have DJs on a Friday and Saturday night where the volume is then louder. So when I look at the opening hours that are being considered, for example, on a Monday, Tuesday and Thursday from 6 o'clock, the sound that's going to be coming through at that time, I've had to put on this Tuesday just passed, I had to put my 2 boys to bed listening to Fusion. And that would have been on a school night, which I'm deeply concerned about. For those of you that don't know Bar Nothing, we've been established since 2019. We're a neighborhood community bar. And the activities are only not late night music. We're a platform for artists. We have a monthly market. We are a space, a safe third space. And I'm also concerned for the safety of my customers. On Saturday, the 24th, I've logged with the police. There was an incident. I'm not sure if this was logged anywhere else, but I have a witness statement from my security where there were 2 instances where a Fusion customer had come up from the basement and had to be restrained from aggressive behavior towards 2 sets of my customers leaving the bar, which is deeply concerning. And as you know, prevention of crime and disorder and public safety, I think this should be considered. The report is with the police. Unfortunately, they are not here today to comment. And I don't know if that's been logged anywhere else. As I said, the bar's been open for 6 years. It was established. It's established 6 years ago by my husband and I. I am recently widowed, and this space is not only important for the community, it is a legacy, and I fear for the future of my business. And with this level of sound coming through, I will not be able to operate the way that I have been in the last 6 years. And as I said, the majority of the time is a lounge bar or place where artists can come in, where we support local and touring independent artists and musicians. And we will not be able to do that if the sound continues to be as it is coming through into my business. And my deep concern is that if it's only going to be monitored through complaints, and not actually monitored correctly. I have a deep concern for the future of my business and my livelihood, and I also live there. And the mental health that it's hard enough to be in my personal situation is difficult enough to run a business as a single parent, grieving, and then to potentially have it being severely disrupted because of just a lack of consideration for my business and as a neighbor and the neighbors around me. It's a beautiful ecosystem that exists on Cliff Terrace. We're neighbors, we're friends, we're businesses that all work together, and the lack of consideration and respect is deeply, deeply concerning.
Thank you. Does the applicant have any questions? Do any of the responsible authorities have any comments or questions? Do members of the committee have any questions? No. Okay. Thank you very much. Could I then come to objector number 8, which is Felix Cohen, to present his case?
Thank you, Chair. I think it's important to note, I think in a licensing hearing like this, everybody's quite emotional. We've all touched on elements of the licensing objectives, the prevention of public nuisance, the prevention of crime and disorder, and any risks to public safety. As I say, I'm speaking as a representative of residents of Paragon Court, the building opposite. This is also a Grade 2 listed building. It also has single glazed windows across the front and back, going into 25 individual residences, all of which have bedrooms at the back. So we're all exposed to noise. I've been asked by my neighbours to come and speak and represent them here. A huge part of this comes down to the late night economy in the area. As it stands, as has been alluded to by other speakers, there is a great late night economy on Cliff Terrace. It's very respectful to local residents. Local businesses are in touch with people. Many of us are friends. Many of us know each other, talk about issues. Certainly any issues that there have been in the past have been addressed very, very well, and we're very concerned about adding a significant weight to the existing late night economy in this area. I know, and I've spoken to my local councillors and to our local MP, in the recent licensing policy that the licensing committee have published for 2025 to 2030, there is no exception made for cumulative impact. I've asked about whether that will be addressed, whether that will be picked up, and it's been made quite clear that there is no plan to have a cumulative impact policy. Unfortunately, that kind of leaves us in a position where we have to treat this as the straw that breaks the camel's back. We have already noise at late night. We already have problems with antisocial behaviour on the streets. We have problems with littering. We have problems under all of these areas of the licensing objectives. I'm aware that the prevention of harm to children really is quite specifically about children being given access to alcoholic beverages, being in late night spaces. But of course there are many children, many babies, many kids growing up in the flats, in the buildings around these late night venues. As it stands, we are already struggling with the noise. I would ask that the licensing committee, please, if not granting this license, please consider bringing it in under the existing late night that we have. If they're to be granted a license, it should be to close at 1 a.m, not to extend the late night hours, late night noise, antisocial behaviour, risk to public nuisance, to crime and disorder that we already have with so many late night businesses in this area. Thank you.
Thank you. Does the applicant have any? Moving on. Okay. And do any of the responsible officers have any questions? Do any of the committee members have any questions? Thank you. Okay. Moving on to the last objective, which is Mr. Yates. Can I just confirm, Mr. that are you speaking as you are listed as Councillor Yates? Are you speaking as a councillor under 20.1, or are you speaking as an individual? Speaking as an individual. Thank you. So I was
waiting for there we go. Yeah, sorry, Rob Yates. So I'm speaking as an individual. I am also a councillor. I'm also former mayor of Margate and local Margate resident, and I'll just give a bit of a preamble. So I do, as Felix Cohen has mentioned, there is a scene, a business scene here, and it is very well, they work very well together. And I think what's great about Margate is the community works together. And as I go on, I'm going to ask the committee to reject this application, to be honest. And I'll go into the exact reasons why under the 4 licensing conditions. A bit of context though as well about Margate is that we had Freddy's nightclub close recently in Margate. That was one of the latest opening nightclubs, and I believe it was closed due to police chasing someone inside and then the owners of that nightclub not hiding the person running away. And there is tension and there is crime in Margate, and the latest opening club is going to attract the people who are drinking the most. And as I go on to, like, this application didn't want the license conditions in front. They wanted 6 a.m. license. So that's a bit of context to start with. So prevention of crime and disorder. As I probably explained to my questions, it's very disappointing the police aren't here, as I believe from speaking to the businesses and residents that there have been incidents already, and that's under a tens. And it would have been very nice to hear from the police to say, okay, how many incidents have there been? Because I believe there have, and I think we've had testimony to say that tonight. From speaking to the businesses, they're also concerned. So this is not a few businesses, this is, I would say, the majority of the businesses on this are concerned, and that's why we've got a big turnout from them tonight. And it's not just 1 or 2 next to it, but you've actually got businesses right the way across, from off-license daisies. The business that sells little gift shop, they've got concerns. Bar Nothing's got concerns. So pretty much all the businesses that I've spoken to, every single one has concerns about this license application from a crime and disorder point of view. Another kind of element of this is the kind of the mixing of punters. So you've got a queue outside Fusion nightclub, which will be formed because they're advertising widely. You can see their posters along North Down Road. And there'll be a queue outside, but that queue will be directly in front of Bar Nothing, most likely, where there are benches sat, benches placed, so people can have a nice drink, see the view, have a drink, and that interaction is going to increase, in my opinion, the risk of crime and disorder, because you've got 2 different type of punters outside interacting. And this leads me on to public nuisance, which is the license says you can only have 10 people smoking outside at a time. That is unenforceable. You cannot enforce that because they'll walk away 5 meters and say, oh no, we're not, we're leaving the club, and then I'll come back in because they've got a stamp on their hand. I can't see any way that you can enforce 10 people smoking outside, because I know more people smoke outside than that, and I don't see that being enforceable. 60 people in the nightclub, I think that will lead to big queues, and then you've got big queues, 10 people outside smoking. It's going to be chaos, I think, especially if the venue's like set up for 200 people, but 60 people are allowed in. I don't see that working on a public nuisance point of view. The type of music is very thump, 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 and I've been to Bar Nothing, and I've seen myself, the background noise coming from the venue is disrupting the venue already. And that's created tension, which you can feel in this room today, and it's unpleasant, and that's a public nuisance in my opinion. Another public nuisance is noise. So, from my understanding, a definition of public noise nuisance is 2 properties with noise levels above the recommended rating. I think it's disappointing that the noise testing only began after the 10s were granted. So it wasn't that. It doesn't seem to me that, and you can correct me, ask questions or respond if you want, but from my understanding, the noise testing that was done at Bar Nothing was done after the first few 10s events happened. So they opened their venue without doing any noise testing, as far as I'm concerned, under the 10s. And that kind of creates a concern from my view, because it just highlights a lack of care of working with your neighbours, which I think is endemic of this application, as we'll come on to, as I try and summarise. Protection of children from harm. I'm 38 years old. I've commented to my friend, because I go and drink down there at the local venues, and I said, the age is, I thought some of the people outside the venue looked under 18, and now I'm 38 and I'm getting older, and they're probably 20, 21, 22, 20, but they looked very young, and that did concern me, as they may be trying to attract the younger people, but I don't know why, but they are very young people going in there, from what I've seen. Public safety, again, we've, as I've explained, there's already been little issues. I think when a business says to another business, can you come up and hear the noise levels, and they say no, that's really disappointing, and that is in itself a public safety issue, I think, because it creates tension that shouldn't be there. Disappointing again, like the police can't be here. The fire safety side is it's absolutely insane, in my opinion, that we've granted this license already for a temporary event license when the fire brigade have been very, very clear today that 60 people is the max. There hasn't been the fireproofing there. The fire detection was not fully in place. The emergency lighting wasn't fully there. Now, this is a venue, and there have been famous fire incidents with nightclubs around the world, which leads to significant death and harm. And to not have those basics in place, fire detection and fully in place, is really upsetting. So I think just on public safety, I think there's a point here to be made on this. What the committee is agreeing to or looking to agree today is to build a relationship between Fusion Nightclub and the applicant, and it's about trust. What really concerns me is the application was put in, 250 people, 6 AM license, no noise testing, from my opinion, has been done prior to those temporary event notices and events happening. Neighbours and residents, businesses, the business above was not consulted. No certificate of lawful use provided to planning. Now, and that you don't take that into consideration because it's a planning issue, but it builds a case about trust that the council has to try and approve something here. There's high risks in case of fires, which hasn't been, in my opinion, fully ironed out. Documents are still required. This all screams at me risk. And the evacuation process, it seems like they were actually misrepresented their position within their own application. And for me, that builds a kind of lack of respect between a business and the council. And it's for those reasons that I think you should reject this application. Thank you.
Does the applicant have any questions? Thank you. And are there any interested parties that wish to make any comments? Okay, we can move on. And are there any members who wish to? Councillor Bayford.
Thank you. Mr Yates, with respect, some of the points you've made have been speculative and somewhat subjective. You've used the expression, in my opinion, lots of time. Do you have any evidence to support comments that you've made, such as new businesses that will attract the attention and the or the size of the queues and things like that? Is there anything you have that's evidential to support your comments? Thank you.
Yeah, that's a fair question. I think, so part of the reason I'm here is because I frequent the off-license, I frequent Bar Nothing. This is an area that I go and socialise. So I've heard the noise firsthand from the thump, thump, thump of the background music from Fusion Nightclub. Before it's even 11 o'clock, I can hear that. I've seen young punters outside the venue milling around, and it's a strange atmosphere now that it's opened, because there's this new crowd hanging around. And yeah, when I envision the future, I'm envisioning it in the case that the council, the committee today agree the license, and potentially the venue gets, if the license is granted today, and say that the fire safety issues are resolved and it goes from 60 person capacity to larger, I worry about that area, and I think the committee would then be back again because of public noise nuisance from noise testing, and potentially for other issues. But as I mentioned, Freddy's, as the ward councillor for Freddy's, I saw that once a licence is granted, it's very hard to get that changed. And I had numerous complaints that I submitted about Freddy's nightclub, the noise from the smokers outside, the disruption and the crime caused, and not much happened. So I think now is the critical point that councillors can really make a difference to protect what is a thriving community. Thanks.
Are there any members that would like to speak on this first point one? Yeah. So if that is kind of the end of public speaking, and we can move on to summing up. Do the fire service, environmental health or licensing wish to sum up? Okay. Do any of the interested parties wish to make a sum up? I think Mr. Yates has... No. Okay.
Sorry.
Hold just one second. Just been advised that somebody did put their hand up to sum up.
Yeah, I don't know if anybody else would like to. I think I'd just like to kind of sum up from a slightly different perspective from my actual representation, which is also as a licensee myself, and to echo some of the points that Councillor Yates made. I think in a case like this, a business coming into an existing community with a big residential element and existing businesses, it reflects well on that business to consult with other people, to speak to other people, to understand how they're going to fit into an ecosystem that's there, to demonstrate the best intentions and the best practices. I would love to be able to say that I felt that's been the case with the applicant. I don't feel it has as a local resident, as a local business owner. I think I would love to see a demonstration, and I understand that some conditions have been put in place by environmental health, by the police, by fire, by the licensing officer themselves, and I'd like to thank everybody for their work in doing so. But I think if the committee were to choose to grant a license today, and that's certainly, I know, sadly not my wish, I think a license that's as minimised as possible in order to give the applicant a chance to demonstrate that they are able to operate in a way that fits the local community, that doesn't impact local residents, local businesses, and they can come back to the committee and look to extend, to add hours, to add operations, that may be an opportunity to set things back on a good foot for everyone.
I'd like to sum up as well, I'd like to sum up as well, seconding what Felix and Rob Yates have said, and ask this application to be rejected as well, and just imagine how you'd feel if it was outside your house.
If there is no one else wants to speak, I will then ask...
May I make one final statement? Sorry.
Yeah, quickly.
Sort of a summing up point, just to do with the questions from the fire department. I'm just concerned about what will happen if the licence is granted today from a legal standpoint, if the current sort of assessment of where the regulations are being adhered to in that infusion basement, if that then means that the basement will be able to be open if the licence is granted today without being in formal agreement with fire regulations by law, as seen under law.
Thank you. At this point now, the applicant will now have the opportunity to sum up their case before the deliberations begin.
This building's been out of commission, the basement's been out of commission for a number of years. We're bringing it back into use. We may not be part of the local community, but we will become part of the local community when we open fully. There's been accusations about things with TENS, but TENS have different procedures to the formal licence, and we've complied with the procedures under the TENS. We've not had any complaints from the police. The police are not here today because they've not raised any objections to the licence. So, and there's been accusations that we haven't listened to the residents. We've looked at the complaints and we've gone through those and tried to address them as best we can. We don't have the addresses for people, they're expunged. So it's not that we can know to go and contact people, we don't have them. That's the whole point of making complaints. Well, okay, but with shops, but we're more concerned with residents. So we've looked at the issues, we've lowered the hours. We've agreed to a very stringent noise level between us and the bar above, which we've got to comply with or show that we are complying with. And the owner of the bar above will have opportunities because they will come and do testing. And if we're exceeding that at any time, we place our licence at risk. So I would ask that the committee grant the licence as endorsed by the officers of the council.
Thank you. On that note, I would like to thank you all very much with the exception of the thank you very much. With the exception of the subcommittee members, the Democratic Service Officer and the interim senior litigation lawyer, please can I ask that those present to leave the chamber so the subcommittee can come to a decision. You will be invited back for the decision to be announced.
You did very well there. Proud of you.
And I do apologise, I forgot to turn off. I would like to now invite the interim senior litigation lawyer, Joseph Katangi, to read the summary of the subcommittee's determination.
Thank you, Chair. Upon considering whether to grant or refuse to grant a premises license at Fusion Basement 17B Cliff Terrace, and having considered the documentations and representations made by the applicants and the parties involved, the licensing subcommittee was satisfied with the recommendations of the responsible authorities. However, the subcommittee were not satisfied that the public safety objective in relation to the fire risk as to whether it has been complied with and full approval has not been granted by the fire risk services. Therefore, it is the decision of the board to refuse to grant a license at Fusion Basement 17B Cliff Terrace, Margate. The applicant has liberty to reapply upon approval from the fire risk services in relation to public safety. This decision has been made in line with Thanet District Council's licensing policy and objectives within the Licensing Act 2003. The applicant or their representative may appeal the committee's decision at the Magistrates' Court within 21 days. Thank you.
Thank you. This concludes the business for this meeting. Thank you very much.
They're going to come back, I can see it.
Well, if it comes back, it comes back. If he's complied with it, it'll go.
No, I couldn't say any fairer than that, would you? And to do it the way that it doesn't look vindictive.
No, the thing is, if it goes up in smoke, and you said yes, then you share.
Well, I know. It's funny, I've got funny on mine, but I don't have difficulty making decisions. For me, there's right, wrong. And for me, straight away, as soon as she said that, I thought, no, that's not.
And it's not down to anything else other than fire brigade and damage.
The rest of it, I'm afraid of.
If it comes back, if it came back, and all that had been put right, then it's not a problem.
Which it may well do. Yeah. But if they think they've got away with it, well, it's not for the right reason.
Nothing to do with us, is it?
It was funny that that very respectful lady who cried, she's now got a baseball cap and a... Good God. That was worse than Casey said.
Read the ready for somebody opening the champagne.
Did you hear what I said? That was because when I got vice chair, I got it at 2. They took the vote at 2 o'clock. I went into the council chambers meeting. At 3:30, the chairman said, "That's it, go, I'm going on." I left me to it.
Hello, thank you.
Thank you again.
Hi.
Can I ask you a quick, does that mean they can still get tax?
No, they can't use it. They have to apply again.
They can apply for that. They are liberty to apply.
They can apply for it?
Yeah.
Does the problem with fire safety come into tax?
And other things.
Yes, it just depends on the
fire issues.
application.
Fire issues. But that's not down to
the
them.
procedure for tents and for premises is slightly different. So the risks are also different as well. So it's completely different.
Yeah, I'll try and clarify it.
Don't particularly want to get involved with my residents who are trying to come over here and go.
Trying to get what?
Trying to come and have a chat, and we can't do that.
I don't know why.
But you are. Yeah, exactly. I didn't mean to put you in that one, but on the minutes, on my notes, on my notes, that at that point they put you down as a councillor.
Yeah, no, I'm a resident.
Yeah. So I just wanted to clarify that because what was wrong with you the other night?
Me?
Yeah, you look dreadful.
Oh, I'm on a low-calorie diet.
Ah.
So I'm on haven't got much food in the home.
No, you look like you're on death's door.
I lost a stone in a year.
Yeah.
Hi, right, so we have eventually finished, so I'm just going to go back and put my stuff in the car, then drive down and just get a few, just do one. Is there anything you want to read?
Oh, I was just saying to Charles.
I didn't buy any.
Yeah, that's from 3 o'clock this afternoon.
Just have a tripod one.
3 to 6.
Oh, Charles, yeah. Charles, don't disappear.
Okay.
13 kilograms.
Absolutely, unfortunately.
Be careful, because you did not look well at all the
All
other
right, is
night.
there anything at home?
And I'm crossing everything when I said that, because we might have to have a by-election.
All right, I'll see you in a while, I won't be long anyway.
And you know what I mean.
Have your legs taken off by the knees. And you won't be right lot short about it.
Right.
Funds.
See Will, can you contact him? Because I haven't got my contact.
Yeah.
So next week is a meeting. Right, let's went. And I need a lift. All right. I did message him, but he's not answered. Oh, wait. Thank you very much. Thank you. Right, okay. So, yeah, okay, I'm not sure what bits apply to me. Okay, because talk about employing business and professionals, and I'm not sure how I word it.
Okay. Financial, do you have any financial describe job
Hi everybody, thank you.
Thank you, thanks for help today.
Yeah, all right, yeah.
Yeah. And name of the employer?
TDC. Yeah.
Unless you're employed elsewhere.
No.
You're not firm?
I did because
At the moment you're not employed.
yeah, and I don't get paid
Yeah,
parish.
so yeah.
That
So,
answer is no.
yeah. You're a director. Do you sit on any boards?
No.
Where you get a remuneration?
No. I'm not sponsored, or am I sponsored by TDC?
Sponsorship, any body who has made a payment
No
in
payment.
respect of your election or expenses incurred during carrying out any duty. You claim expenses from TDC, don't you?
I haven't done, but I will do.
But
At this moment, as of from now, I'm not a Kent County councillor.
In this case, for example, if you are going to a meeting, you claim expenses for going to River Store meeting.
Yeah.
So it's TDC.
That's no. I pay water rates.
The board. This is the board. You will be person being on the board. Company that's the interest. This will be none.
No.
Land or buildings in the board's area.
I own one on there.
Yeah.
None together at the moment.
Mention that.
Yeah.
Nice to see you. Take care. Does that mean they can still operate under that? Yes.
No, no, I've got these to my house.
What was the administrative issue?
It was just, it wasn't something that was dealt with, so.
We didn't respond at a certain time.
Yeah.
Membership.
So yeah, no, don't buy for attendance, as long as they've just got 60 people on there.
So it'll be 60 people, what time till?
Whenever. So they have to nominate me.
Yes.
No, so that's right.
Yeah, the environment, I'd like to say under the licensing act, the police and environmental health are the only ones who can object to attend.
Okay. Cool. Thank you very much.
All right then, see you later.
See you later.
Thank you. Thanks, Mark. All right.
I remember it. Yes, that's it.
Okay. That's good.
I knew it'd be like that.
Good. Oh, this is yours, am I right?
Yeah, it's mine. Sorry,
Okay.
it's got me.
No, that's okay. Oh, good.